Regulated Industries meeting to order. Folks, in your folders, you'll have the bills that we'll be talking about in the order that they're to be discussed. The first one's House Bill 630, Representative Wiedauer. The floor is yours. If you'll just briefly review this bill with us, and then we probably have a few people signed up to speak.
Thank you, Mr. Chairman. Obviously, we heard this bill last week. This is, again, coming from the Blue Ribbon Committee over the summer, looking at all the different licensures. On this bill, we've got two. One is for the State Board of Registration of Used Motor Vehicle Dealers, used motor vehicle part dealers as well, and applied behavior analysis. So those two licensure boards are getting reformed. Actually, the behavioral analysis is just a change in the name. There is going to be a friendly amendment, Mr. Chairman, on line 60, where it says 3 members shall be independent used car dealers. We're simply adding that at least one of whom shall be an independent used car dealer that sells at least 100 used motor vehicles in the state of Georgia each calendar year that primarily or exclusively sells motor vehicles online. That'll be the only, again, friendly amendment. Other than that, the bill stands as I presented last week.
Okay. Committee members have any questions? This was presented some last week. I'd give you this opportunity to have 2 people signed up to speak. Any questions from the committee members? You got one?
Not yet.
All right. Then I'll call on Colin. Is it Mathing? How you pronounce that? Muthing.
Don't worry.
Okay. Introduce yourself. Tell us who you're with and your thoughts on the bill.
Sure. Good afternoon, Chairman Cowser and members of the committee. My name is Colin Muthing. I'm past president of the Georgia Association for Behavior Analysis and currently work on public policy initiatives with the organization. In 2022, we presented a bill to create a licensure board for the profession of behavior analysis. This law was passed in 2022 and went into effect in July of 2023. Since then, no rules or regulations have been adopted and no licenses have been issued. The board is not operational as of today. We respectfully disagree with QABA's approach to adopting a new accreditation body. The law we presented and passed in 2022 allows the licensing board to adopt a new certifying entity. OCGA 43-7A-25 defines the term certifying entity as the Behavior Analyst Certification Board or its successor or another entity that conducts programs to certify professional practitioners of behavior analysis that are accredited by the National Commission on Certifying Agencies or the American National Standards Institute as identified by the board. We have tried to work with and engage with QABA, but they have not responded to any of our requests and instead are attempting to sneak this clause, adding QABA into a used car bill. Finally, I'm a behavior analyst, but I'm also a licensed psychologist. I was appointed by Governor Kemp to the Psychology Licensure Board, and we are dealing with a similar issue. There's a new psychology accreditation agency outside of the Association of State and Provincial Psychology Boards, which currently is the sole accrediting agency for psychology. This new accrediting agency is engaging state licensure boards around the country, including in Georgia, to educate us on how their accreditation is similar or different from the current sole accreditation agency. In this way, the profession of psychology is determining if the new accreditation meets the professional standards. This is how psychology is doing it, and I urge you all to let the Behavior Analysis Licensure Board do the same. We appreciate your time and ask the committee to respectfully strike lines 444 to 453 and give the licensing board an opportunity to become operational before we further amend the law. Thank you for your consideration.
Will you tell me, I'm not familiar with that profession. Maybe it's because there's never been one licensed yet, but what does an applied behavior analyst do?
Applied behavior analysts work with a variety of different individuals. The vast majority of behavior analysts work with children on the autism spectrum, teaching them new skills or working to reduce challenging or problematic types of behavior. So the vast majority work with autism. However, a lot work with traumatic brain injury, geriatric, drug addiction, across a variety of different types of areas and people that they work with.
And what type of education do you have to obtain that qualification?
It's a master's degree to get a license or to be a board certified behavior analyst or a doctorate degree.
What is the name of your organization again?
The Georgia Association for Behavior Analysis.
Okay. And do you have to be a member of that to be a behavior
No.
analyst?
Nope,
Okay.
that's just the state organization.
Do you have to be a member of that organization to be licensed?
No.
Okay. Anybody else have questions?
I got one, Mr. Chairman.
All right. Senator Summers, you're recognized for a question.
Thank you, Mr. Chairman. Make sure I understand you correctly. Part 2, Sections 2-1 in the bill. You're wanting to strike that section because this organization or this board has not been accredited yet or put together or whatever.
Correct.
Will you kind of explain it a little more deeply?
So the board hasn't been created yet and hasn't issued a license. The law that we passed also permits the board to determine if a new accrediting agency is appropriate for the profession. We would respectfully like the board to determine if this accrediting agency is appropriate for the profession or if the Behavior Analyst Certification Board should continue to be the sole accrediting agency for this profession.
Thank you.
All right. I don't see any other questions. Thank you for being with us today.
Thank you.
I'm sorry. Senator Brass?
I got a question for you, Mr. Chairman.
All right.
I thought we were talking about used cars.
Most of the bill includes used cars, but the very last couple pages, 18 and 19, have this. Was this amended in the House, or this to add this on, or where'd that come from?
It's a committee sub, yeah.
Okay.
So,
House committee.
Chairman, so this is, that's right. So, again, we have all these licensure bills going through. The only thing I'll actually comment on the last comments that were made, we've worked very hard to find ways to make licensure easier in the state of Georgia. I don't, and I'm respectful of all opinions of where we're at with this, and certainly appreciate the testimony. I don't appreciate saying we snuck something into something. We're trying to handle a lot of different licensure bills, and these did get combined, but they do stand on their own merits. So I'll just say that.
That's what they got it.
Did you have any objection to that sort of traveling along with your bill?
Now, and at the time, we cleared it with all floors, and
Okay. All right. I have one other speaker, and it's Miss Gabby DeLeese. She wants to speak on this same little section.
Great. I'll be brief. I know majority of the people here are not here for this bill. Thank you, Mr. Chairman, members of the committee. My name is Gabrielle DeLeese. I represent QABA. So the language in the bill right now that we are proposing is to include behavioral analysts who are already working in the state. These are not people that are coming in that have not had jobs before. These are behavioral analysts that already have jobs and are working at military bases all across the state right now. Unfortunately, I couldn't have any practitioners be here today because they're busy assisting clients, and majority of them are at Fort Stewart down in Savannah or at Fort Eisenhower. So my practitioner is written in the TRICARE manual. They primarily work at military bases and with service members' children at EMFP bases. So to be fully transparent with you, we discussed this offline, but to share also with committee members, the only board members that are on this licensing board are accredited through one credentialing organization, so they have a monopoly right now on licensing. I'm not there. That is the issue that we're trying to do, is to have both the certifying entities that are currently working in the state just be written equally in the law. Because the arguments that were made that we should just wait for the licensing board to figure it out, well, at Fort Hood in Texas, when we waited to just have the licensing boards figure out what's going on, the licensing board was all credentialed through one certifying entity. And because they were all certified through that entity, they only chose to license people also within their certifying entity. And my practitioners at Fort Hood had to stop working, and the Texas licensing division had to get involved, overrule the board, and allow for practitioners to continue to work. That. I just want to be clear. These people already work in the state. These are not people coming in. These people already are accredited through a national certifier that is vetted. The board has identified that it is an accredited ANSI organization, but we just want the licensing board to not have the option to choose who they want to license based off of any biases, and that both of the practitioners, certifying entities, are equally written in the law, that there's no bias. That is the only objective of naming QABA in the law. I understand the comments that we want to get the licensing board up and running, but I would hate for that to be at the cost of someone losing their job or not being able to get their license. So,
So when I'm on page 18, down at the bottom lines 450 and 451.
yes.
Is that what this does, is add a second credentialing board that can qualify
Yes.
people for the
So
license?
currently written in the law, it says, board certified behavioral analyst, that is the credentialing organization, or ANSI accredited organizations, which as identified by the board, that the issue is that we just want, if you are a practitioner in the state, you meet your hours, your supervised hours, have your degree requirements, that licensure isn't a barrier, and that there isn't a decision to choose, as identified by the board can decide if I want to give you a license. You already work in the state, you should be able to get your license. That is the whole purpose.
So you add the Qualified Applied Behavior Analysis Credentialing Board in
Yes.
addition to the current board.
Yes.
Either of those could now
Yes.
credential you to be licensed or grant you a license.
Yes.
So who's going to run the board? Is
So the
that-
the board's already been appointed. There's members on the board right now, and currently they are all credentialed through the BACB.
Okay.
So that's why we're just wanting to make sure that there isn't any bias, since there's a monopoly right now on the licensing board. And we just want to ensure that practitioners that are working in the state can continue to work.
All right. Any questions? All right. Senator Rhett, you're recognized for a question.
I was just curious as to why that lines 44 through 53 couldn't be put in a separate bill and stand on its own merits.
You asking me that, or the author of the bill? Senator,
Yes.
Senator, I think you should direct that to
I'm
Representative
sorry.
Wiedauer.
I was looking at you.
Yep.
It certainly could. I think that like many pieces of legislation this time of year, certain things get combined to get across the finish line as we're running out of time.
You might regret having been so nice to save this from yesterday, the last meeting, to give this, I guess this was the governor's amendment or the
You might-
administration's on the first one that replaces line 60.
This was just an additional measure in licensure that we were trying to get done. But again, I hear the senator's point loud and
Okay.
clear. So I'll let you, I'll, at the will of the committee,
We have in our folder two different amendments that were presented to me. One, I believe, came from you, that replaces line 60 with the new.
Yes, sir.
But there's another one that essentially, if I'm reading it right, strikes this other licensing board out of your bill.
Okay.
And we're going to see what the committee wants to do. But you were gracious to allow the First Amendment, and in the process of doing that, you gave time for a second one to get proposed. So we'll see what happens. Any other questions from committee members? Do you have any closing comments? I have one from Chairman Brass.
Thank you. So I'll be honest, I'm not in love with these two bills being together, but I do understand, sometimes it just happens and the need for it. So I want to focus specifically on your policy. So this new board, Qualified Applied Behavior Analyst Credentialing Board, is that board, does it conduct programs to certify professional practitioners
So it is
of
not.
behavior analysts?
So QABA, they're not like a new board. So they were established in 2012. So practitioners have been getting credentialed through this entity since 2012. The only issue now is that since we're establishing licensure for behavioral analysts, that they have to be accredited through either one of these organizations. And the only point of the bill is just to make sure that both certifying entities of practitioners that are already working in the state are both written equally, so that when licensure rolls out, there isn't a delay in services. Because
No, I get that, but it's saying under current law, it names out this one entity.
Yes.
Behavior Analyst Certification Board, Inc. So well, first off, I didn't know, I thought we didn't name corporations or businesses in law, but apparently we do.
Yes.
But also, it gives an option or another entity that conducts programs to certify professional practitioners of behavioral analysis that are accredited by the National Commission. Does QABA not check that box? Are y'all
So-
accredited by the National Commission?
So we're accredited through ANSI. ANSI is the American National Standards Institute. It's the largest certifying entity in the Western Hemisphere. They're just credentialed through different certifying entities. So they have to go through rigorous exams when they write the exams that the behavioral analysts have to take, and they have to uphold certain standards through ANSI in order to have the certification be through that entity.
Okay, but do y'all not check that? What I'm getting at though is I don't know that if y'all check this box already, I don't think this law is needed, because you would qualify under or another entity that conducts programs to certify professional practitioners of behavior analysis that are accredited by the National Commission for certifying agencies or the American National Standards, which you just said. I thought I heard
Yes.
you say you checked that box.
Yes.
So why would y'all not qualify under that?
Because-
It can be that one, the BACB, if that's what it goes by, I don't know. But it could be that, or it could be this other thing, and y'all appear to check that box. So I don't understand the purpose of the.
So the
I don't understand the need for it if it's already in current
No,
law.
I totally understand your question.
Okay, thank you.
So the need is because right now, the licensing board, it says as identified by the board in the original law. And we don't want the licensing to be fully transparent. My client, the QABA, we don't want the licensing board, we don't believe that they should have the autonomy to choose who they want to license based off of if you're credentialed through the BACB or QABA. The whole point, we don't want licensure to be a barrier. That's the whole reason why we testified at Blue Ribbon Study Committees, why we were engaged in them, why we were involved in this conversation on a Blue Ribbon Study Committee bill, is because we want to remove barriers from licensing and not allow the licensing board to have the autonomy to choose who they want to license based off licensing politics. This is healthcare. I just don't think there's room when we're working with vulnerable populations to have personal biases or certification or licensing politics get in the way when we're working with children that have developmental needs.
Senator Brass, I read it the way you do, but it seems as if the licensing board that's inactive has chosen only the Behavior Analyst Certification Board. They have the authority, the ability to choose another board if they want to, multiple ones, but apparently they have not done so. So this forces them to approve her organization as well. You're right, they have the authority to do it already. And if
Okay.
they would pick them,
I
they
see.
wouldn't need this bill. So they're trying to force their hand to allow, am I reading that right?
Yes.
Abby? Okay.
I just want my practitioners who are already working in the state, already working at Fort Stewart, Fort Eisenhower, Fort Moore, I want them to keep working. I don't want licensing to be a barrier for them.
Why
They
are
do
they
critical work.
so located in military bases?
So they
Are there a
are,
lot of autistic kids on military bases? or
so
is-
great question.
Thank you.
He's full of them.
So my practitioner is written in the TRICARE manual, which is military insurance. So we are very lucky in Georgia that every single military base in Georgia is an EMFP designated base. So that means if you have a special needs child or family member and you are technically based at a military base outside of the state, you can put in to transfer to Fort Stewart because we have a great behavioral analyst workforce
Okay.
down there that can work with your children that are credentialed and certified through the Army.
And TRICARE approves these
Yes.
licensed people.
Yes.
Senator Lucas, what did you always say? You just figure this one out, what it's about?
Mr. Chairman, I'm late. I left the
You
meeting. You
okay?
left early.
You're a quick study.
The question, is this something different than the subject matter that I'm reading on used car dealers?
It was hidden in this bill at the very last page. The author just didn't mention it to us at the last meeting.
That's not true.
Or not, we didn't question him about it. Now it's been brought to our attention.
Mr. Chairman.
It was in there in the House substitute, nothing that we added. It passed the House.
Is it dealing with the same code section?
It is not.
Yes, it is.
Well, is it true, Mr. Chairman, that a bill cannot deal with two subject matters, must deal with one?
Had germaneness been raised in the House, the Speaker may very well have said it wasn't, but it is licensing in general, so there's a lot of discretion there. But anyways, any further questions? I just thought you might have figured out by now this was about the money, about compensation for this care.
Well, I'm looking at the money, I'm trying to count it.
Trying to count it.
All right. Any other questions? All right, what's the pleasure of the committee? I do have a question. Senator
It was
Johnson.
when you had mentioned, Mr. Chair, about approved, how many other states, I guess, have approved this organization as a certified entity?
I can answer that question. Sorry, I was walking away. So, written into the law, so this was a similar issue that had just happened in North Carolina. The licensing board got established. They started not approving people's licenses, and they're like, wait, why are we doing this? I thought, says ANSI is identified. Why are you not certifying ANSI accredited organizations, giving them their license? So North Carolina is the most recent person to codify this into statute, to name QAVA directly into the law so that the licensing board doesn't have the autonomy to choose based off politics. Texas, similar measure that I discussed. Their licensing system's a little different. This issue was worked on in California, Minnesota. That was all just in the past year. So this has been an issue that has been ongoing across the country that I don't want to be unfair when I say that, like, yes, licensing hasn't been issued yet. And this is a preemptive issue that we're trying to make sure that these people that are currently working, licensing doesn't end up becoming a barrier because they haven't been issued their license. But we just want to ensure, because this is a trend that has happened in other states, that people in Georgia that have been practicing, working with families already, they can continue to stay working. That is the goal.
All right, you recognize Chairman Brass.
Thank you, Mr. Chairman. How many do you have working off of military bases? How many,
So
whatever they're called?
I primarily have military bases, so I think we have around 150 practitioners in the state, but the numbers I have are primarily for military bases. Like, I got 37 at Fort Stewart, 17 at Fort Eisenhower, 6 at Kings Bay Submarine Base, and it goes down from there. But primarily, as I mentioned, it's Fort Stewart, Fort Eisenhower.
So it sounds like about half and half on bases, half off. Is that about
Yes.
right? All right. Thank you.
All right, what's the pleasure of the committee? We have before us House Bill 630, LC 55051S. This was the House committee substitute, not ours. Got a motion to pass from Senator Ginn. Is there a second? Second. Second from Senator Dolezal. Any discussion or proposed amendments? All right, before yours, you had what I would term a friendly amendment.
Yes, sir.
That's AM 550112. That changes line 60 in accordance with what the governor's office wanted to do.
That is correct.
All right, is anybody proposing that for you?
I'm
All right, I got it. Senator Ginn has offered that. We're going to call that Amendment 1. It's in your folders, AM 550112, and it's seconded by Senator Summers. Any discussion? You do perceive that as a friendly amendment?
I do.
Okay. What's the pleasure of the committee? All in favor of Amendment 1, raise your hand. Any opposed? This is AM 550112. All righty. And any opposed?
I'm opposed to the bill.
Okay. Fair. Then you probably don't want that amendment either, do you? Okay, we got Senator Lucas, the only opposed. That amendment passes, and now Senator Albers, you're recognized for the other amendment that's in our folder. I'm going to call it Amendment 2. It's AM 550110. Would you just describe it to us, tell us what you're doing?
Certainly, Mr. Chairman. Let me just say, before I get to the amendment part of this, I appreciate what everybody's thinking about and trying to do. But I want to get back to one of our speakers, Colin, who I think summarizes very well. There are no rules set up yet. There are no regulations set up because it's not even operational. If we're going to trust people to serve in these capacities, we ought to give them the ability to do their jobs. We have done great strides since some of us who've been here for a minute first passed Ava's Law and did all this other great stuff for this state. So I have utmost confidence they'll do the right thing. I don't know of any place in the OCGA that we codify a corporation into the law. I think that's a dangerous precedence if we're going to start doing that, because they are not, well, no, that's a not-for-profit. This is a corporation that's put this bill. I understand, there's a non-for-profit, this one is not, but either way, I'm concerned that we're setting a bad precedence here. And again, I don't think it's needed, because I think they'll be able to do this. The whole purpose of the board is to get more people who are able to do this. It is not the exact opposite. So with that, all this amendment simply does is bring this bill back to what I believe the original purpose was, the original subject matter was. It takes out the Part 1 and Part 2, because there'll only be one part of the bill, and removes that last section of the bill. So it is, in fact, I believe, a clean bill.
So you're taking out lines 444 through 454, which is the section 2 at the end?
Correct.
And then you're renumbering everything else?
That's correct.
Okay. We have a motion and a second. Before voting, Gabby, let me ask you this. On those military bases now, if you'll just come up to mic 2 here so we can hear you. Will TRICARE pay for this type of treatment if it's not a licensed behavior analyst? You said this is covered through TRICARE.
Yes.
Do you have to be licensed in order to be paid through that insurance program?
I do not believe you have to be.
Okay, so they're okay now. This amendment, if it takes this section out, your folks can keep working on those military bases.
But if they can't get their license potentially, then that's the only issue.
But that's why I'm asking if they have to have a license to get paid for their work.
Well, now that Georgia requires licensing for behavioral analysts, once the board gets out and rolling,
But it hadn't licensed anybody yet.
hasn't licensed anyone yet.
So
You are
right
correct.
now, there's no licensed behavior analyst in Georgia. Those
No.
ones on these military bases, anybody pay them for their service? Is it TRICARE insurance, the military
Yes,
insurance?
and
Okay.
private behavioral companies that work in the area as well.
I just I wanted us to know if we've got a bunch of autistic kids on bases that are no longer going to be treated, because TRICARE won't pay for it unless there's a licensed behavioral analyst. Right now, they're not licensed, and they're
Yes.
doing the work somehow, right? Okay.
Yes, but once licensure gets rolling, and you have to be a licensed behavioral analyst in order to practice in the state once we begin licensing.
Okay. Then you're going to need to lobby that board to say, y'all better take in other credentialing agencies, or else lobby us to change the law if they refuse to do that, right?
Yes.
Okay. Any further discussion? Thank you. Any further discussion on the amendment? Yes, sir. Senator Lucas, you are recognized.
Mr. Chair, does Part 2, Section 2-1, is it in the same code section?
It is not, and this proposed amendment would remove it totally from the bill.
All right, I just want to make sure, because if we put this in, it is subject to be questioned as to whether or not the bill itself is legal.
Right. You're correct. It is, we have a single subject matter rule in Georgia that laws must contain a single subject matter. If challenged, it could be suspect. All right, all in favor of Amendment 2, and that is offered by Senator Albers, AM 550110, raise your hand. We've got 1, 2, 3, 4, 5, 6, 7 votes. All opposed, raise your hand. I'm showing 3, 7-3, that amendment passes. Now we have before us LC 550581S by substitute as amended by these amendments 1 and 2. Any further discussion? All in favor, raise your hand. Any opposed? All right, that passes unanimously as amended. Thank you.
Thank you.
Representative, do you have somebody to carry that bill for you in the Senate?
Senator Walker.
All right, Senator
Thank you.
Walker, the licensing expert, thank you. Appreciate your patience.
Is.
All right, next on our list, let's keep moving here as the clock is ticking. House Bill 577, you all will remember this as the vape directory bill. Representative Gaines, if you'll come back. If you remember, we heard your presentation and quite a bit of testimony the other day. I had a couple of folks that did send some things in by mail that we put in the folders, but I have at least one other speaker that I promised could speak on the bill today. Did you have anything else you wanted to add? I have not basically received any committee subs or proposed amendments to your bill, so it's just what we got.
No, sir.
Committee members, you will notice a stack of documents that were sent to us by various people that are in our folders discussing the pros and cons of the bill, some for it, some against it. If you don't have anything particular
Maybe
else
after the
to
final
add,
speaker,
you'll
if
be
there's anything to
certainly, we'll
respond
let
to,
you close out. Taylor Leftwich, if you'll please come forward and take that podium up here and sort of give us your thoughts on the bill. I know you were here the other day and I just didn't get to you. I'm sorry. We went long and didn't quite get there. If you would go to that podium.
Some material for you guys.
A little late for that. We'd like that 24 hours in advance so we can put it in folders. But Francesca, if you will see if you can pass those around.
Written testimony for you guys to follow along with the exhibits I'll be referencing.
Okay. I will remind folks, I know we're almost to the end of the session, but we have a policy, if you will bring any proposed handouts to our office at least 24 hours in advance, it gives us an opportunity to make copies of those and distribute them if we feel like they're appropriate. Go right ahead.
I appreciate your time this evening. Thank you guys for allowing me to come back and speak. My name is Attorney Taylor Leftwich and Moore. I am a constituent out in Woodstock, Georgia. I run my own law firm. I also worked under Dwight Thomas for several years before starting my own practice. I've got grave concerns over HB 577. I was signed up to speak last time, and I've prepared material for you guys to see how grave of concerns we have over this bill and the impact it's going to have in the state of Georgia. I work with the Georgia Alliance Coalition and the American Health and Wellness Association, which consists of over 5,000 businesses across the state, vested in compliant, legal, 21 and up sales of tobacco, nicotine, and vapor products to adults in Georgia. Collectively, these businesses employ tens of thousands of citizens in the state of Georgia. They pay millions in taxes to the state. They contribute significantly to our economy, and they comply with laws and have built established businesses in their communities. They have age verification processes in place. Customers who visit our stores must present valid licenses to enter, staff are strictly trained, and adults must be 21 and up for any sales. We do not sell to anyone under 21 in-store or online. Yet HB 577 is detrimental to these businesses. It is a vape ban bill disguised with big tobacco tactics that will put them out of business, out of jobs, and monopolize the market for big tobacco. This is a federal problem looking for a state solution to the benefit of big tobacco and big tobacco only. This is a big tobacco bill. Only 3 big tobacco companies have all 34 of the total e-cigarette products with FDA marketing orders that HB 577 would allow for sale in this state. That's the first exhibit that you have in your packet. Of the 34 products listed, all are owned by just 3 big tobacco companies: Logic Technology Development, Enjoy, and RJ Reynolds. When I did a little bit of research on this, I found out that Enjoy is owned by Altria, which sells Marlboro, Copenhagen, Enjoy, and Juul. Logic Technology Development is owned by Japan Tobacco International, which sells Winston, Camel, Mild 7, and Logic Vapes. RJ Reynolds Vapor Company is owned by RJ Reynolds, which is British American Tobacco. That's Newport, Lucky Strike, and Views Vapes. Put simply, 1, HB 577 will put thousands of Georgians out of jobs and business. 2, it shadows current state regulations and strips adult consumers from freedom of choice. 3, it makes the state of Georgia shoulder the burdens of the FDA. 4, it will eliminate a state-regulated multi-million-dollar industry and line the pockets of big tobacco against the interests of small businesses in our state. And number 6, it will create a harmful black market in our state. Quite frankly, HB 577 is controversial, it's avoidable, it's costly, and it hurts Georgia. The impact on small businesses and adult consumer choice in Georgia will be detrimental. The disproportional impact on adults reverting to deadly combustible cigarette tobacco products will be dire. While we are all in favor of sensible, good-intentioned regulations in our state, HB 577 is a radical ban that simply does not achieve that objective and pads the pockets of big tobacco. Number 1, the facts behind big tobacco and the youth vapor use epidemic. The PMTA process was born at the hands of Big Tobacco, and Altria acquired Juul, which was the catalyst to the youth e-cigarette epidemic and 70% of the vapor market share, for $12 billion in December 2018. The deal combined Altria, which was Philip Morris, the company with the largest share of the U.S. cigarette market, with the largest e-cigarette company, Juul Labs. In April 2019, 11 U.S. senators signed a letter addressed to Juul and Altria expressing their indignation that Juul Labs had teamed up with Altria, quote unquote. The American Heart Association deemed the partnership a match made in tobacco heaven, and that's what we're seeking to implement in Georgia. In the letter, the senators accused Altria of a long and sordid history of spending billions to entice children to smoke through targeted campaigns that intentionally lie about the science and health effects from cigarettes. They added the corporate marriage between two companies that have been the most prolific at marketing highly addictive nicotine products to children is alarming from a public health standpoint and demonstrates yet again that these companies are more interested in padding its profit margins than protecting our nation's children. This is the real monster that is weaponizing a campaign fired against our local businesses that's fueled by Big Tobacco waiting to throw the match. As you can see, the history of Big Tobacco All for Thee But Not For Me campaign is intended by HB 577 for Georgia to follow, with Big Tobacco at the helm, and it's far too flawed for the FDA or our state to implement. The current e-cigarette use amongst youths is actually cited as an all-time low. E-cigarette use amongst high school students increased from 2011, reaching its zenith at 27.5% in 2019, following the Altria and Juul merger. The CDC determined current e-cigarette use amongst youth has declined significantly to an all-time low between 2023 and 2024 to just 5.9%. That's what we're dealing with now, not 27%, not 50, 5.9%. This is due to the Trump administration siding with the vaping industry and raising the age to 21 instead of banning the flavors. That's also an exhibit in the packet that you have. The most commonly reported brands used amongst e-cigarette users actually included the FDA-backed Vuse and Juul, which are approved and would be allowed on this registry. In Georgia, the Alcohol and Tobacco Special Investigations Division issued a report detailing, quote-unquote, strides in its mission to enforce regulations against underage tobacco use. The division continues, it said, to conduct underage tobacco purchase checks with 161 underage purchases out of the 1,595 investigations completed. This accomplishment, they said, highlights the division's effectiveness in uncovering and addressing noncompliance as reflected in the 10% noncompliance rate. This achievement underscores our commitment to regulatory adherence and public health in combating underage tobacco use. That is also an exhibit in your packet. Now, importantly, smoking cigarettes has killed 10 times the number of Americans than who have died in all of our nation's wars combined. I'll repeat that one more time. Smoking cigarettes has killed 10 times the number of Americans than who have died in all of our nation's wars combined. Health experts say cancer and heart and lung disease caused by smoking combustible cigarettes kill more than 480,000 people in the United States annually. Cigarette smoking costs the United States more than $600 billion a year, including more than $240 million in healthcare spending, $372 billion in lost productivity. Experts agree.
How much more you got on this? This bill ain't about tobacco.
Just about 3 more minutes.
Okay.
Experts agree that quitting smoking before the age of 40 reduces the risk of dying from smoke-related diseases by 90%. Now, to tie that in, adults seeking to quit smoking cigarettes are the consumers of vape products sold by the hundreds of businesses being represented to you today, and who are staunchly against HB 577 in Georgia. Now, HB 577, it unnecessarily monopolizes the market at the expense of Georgia jobs, businesses, and taxpayers. HB 577 would require all nicotine vapor products sold in Georgia to have an approved marketing granted order from the FDA. Out of over 26 million products which submitted PMTAs, only 34 Big Tobacco products have such marketed granting orders. This will annihilate an entire licensed industry in Georgia, force Georgians to return to smoking cigarettes. It abolishes adult consumer choice, freedom of choice, and eliminates thousands of local jobs. thousands of small businesses and dispose of hundreds of millions collected annually by our state from local businesses that lawfully pay vapor excise taxes currently. There was testimony last time we spoke about the Louisiana bill and the amount of stores that closed down. 500 smoke and vape shops closed down in Louisiana. In Utah, they passed a similar bill. They're looking to rescind it now and repeal it because 200 stores closed down. It was such a mess up there. And that's what would happen in Georgia as well. There was testimony last session by the Georgia Department of Revenue and Department of Agriculture last session in the House and Senate committees on the predecessor of this bill, which was HB 1260. It was not enacted. But they testified that it would cost the state several $1 million in funding. And since Georgia businesses would no longer be paying the $231 million in vapor excise taxes under the ban, and Big Tobacco would only be paying a one-time $1,000 fee for this monopoly, the expense of funding this monopoly would fall on the backs of Georgia, and the unemployment costs that come with it will also fall on the backs of Georgians. HB 577 is being masked as a Save the Children campaign, when the sale of nicotine vapor products is already legally restricted to adults that are 21 and up. Businesses in Georgia selling nicotine products are licensed, they're audited, they're inspected by the Georgia Department of Revenue and law enforcement statewide for compliant nicotine and tobacco sales. They have age verification processes in place to ensure consumers are 21 and up. They are subject to license revocation, criminal charges, citations, and severe penalties for any vapor product sold to a person under the age of 21. And again, the Georgia Department of Revenue specifically has the state revenue special agents and have listed that statement that's in your packet, which I spoke about earlier. Instead of an outright ban, which HB 577 suggests, this legislature could, one, allocate a portion of the millions in vapor excise taxes currently received from licensed businesses to create funding and enforcement efforts by the Georgia Department of Revenue. Two, they could fund additional state-sponsored public school programs that currently exist in Georgia to divert any underage vaping. Three, they could make it a felony to sell to minors. Four, they could take vape products out of C-stores where they are accessible to people of any age and place next to candy, gum, and other snacks. Or five, require nicotine products to be sold behind counters if we're really combating underage sales, and that's our real objective.
All right, I got some questions for you. Number one, big tobacco's bad, right? They're evil and terrible because they sell tobacco products that we all agree are bad. They cause cancer, they hurt people, make us sick. I mean, that's your thesis. You're against big tobacco because they're for this bill. You're against them because they're bad actors. They sell tobacco. You named us all the products they sell. Mm-hmm. Okay. Vaping's good because it's not as harmful as tobacco.
So big tobacco is not bad, right? But what is bad for Georgia is a monopoly in our state.
Okay. Now, that monopoly comes because you must be FDA approved to sell these products.
Right. And that
there's
process,
a gigantic exception. If you've applied back in 2016, you can still sell them even if they're horribly dangerous and poison because they hadn't been outlawed yet. Right?
That's right.
Now, your companies sell vape products, both from big tobacco and from all these thousands of people that have applied for FDA approval, don't they?
Some do. Some
Okay.
do. Some don't sell any cigarettes at all.
What do they do? I'm talking about vapes. What do they do to guarantee that they're not selling a non-FDA approved product?
So that's a great question. The FDA issues
Thank you.
warning letters.
I'm asking a bunch of them today, it
Good.
sounds like.
They issue warning letters to companies that have received marketing denial orders,
Okay.
and that's what they follow. There's
Right.
a list of warning letters that
So
are
if your people are
issued.
following that, why do they care if there's a list to help them do their job?
The list.
That's all this is a list so your people, your vape stores can look at it and see if FDA has approved it or if it has a pending application so that they have some assurance that it's safe for
That's
the public.
another great question, and
I
we can.
appreciate you
I got
thinking
this
my questions,
with-
just to answer it.
With the click of a button today, and we didn't have to implement a monopoly or a vape ban bill in Georgia to get that.
I don't get the monopoly. The FDA created the monopoly. Georgia doesn't approve tobacco products or vape products or nicotine products. That's done by the federal government, FDA. And you can't sell those products. If the federal government would enforce that, anybody selling something that's not FDA approved or pending approval, it's an illegal product. If you sell it to a 50-year-old person or an 18-year-old person, right?
That's right. So the
Okay.
problem with HB 577 is the language in the bill. It only restricts products that have filed the PMTAs up to 2020. and we're in 2025. New products are filing PMTAs every day. So the language in this bill is legally flawed on its face.
So you're holding the state of Georgia responsible because the FDA is not acting fast enough on applications?
Not at all. I'm holding the state of Georgia responsible for initiating a monopoly in this state and having legally flawed language that would annihilate an industry.
So people aren't going to buy the products that aren't made by Altria and Philip Morris and R.J. Reynolds?
They would. They'd be forced to.
And y'all could sell them, couldn't you?
The only people who would benefit from that are those 3 big tobacco companies.
Because they have gone through the effort to test their products and persuade the FDA that they are safe.
26 million applications were filed in 2020. And since then, several million more have been filed. So all
There's that many vape products?
Yes, absolutely. Yeah, so that's the misconception here, is that all these stores are selling products that haven't filed PMTAs. They all have filed PMTAs, but the only ones that have been granted are the ones that were issued to Big Tobacco, because they quite frankly wrote the language and they worked with the FDA on this.
Okay, and their language says don't make them attractive to children. That's why they outlaw so many of the exotic flavors and video games on the packaging, right? I mean, FDA agrees that we shouldn't sell these children. You agree that. You're bragging that your people check IDs and you got to be 21 or y'all would never sell this stuff.
Right, absolutely,
Okay.
yeah. Nothing should be sold to a minor, yeah, absolutely.
Other committee members got questions?
And I would direct you just to the language of the bill. It's lines 35 through 38. That's the language that has the timely filed pre-market tobacco product application. And it restricts it only to products that were marketed before 2016 or that submitted to the FDA, the PMTA, before September 9th, 2020. But it
Right.
wasn't until 2022 that the Biden administration gave the FDA lawful authority over synthetic nicotine products. So on its face, this is legally wrong, and it already cuts out millions of products that weren't required to file before the 2020 deadline.
I think I just figured out your complaint. You don't like it because this bill cuts out newly filed applications after 2020.
That's right.
Okay.
That's right.
All right. Because those people can't possibly be on this list
Exactly.
because
In
they're
2025.
not in the exception.
That's exactly right.
Okay. All right. Any other committee members have questions? Let me see about, Senator Lucas.
Mr. Chairman. Question to you and Senator Jones, y'all both lawyers.
Woo.
Right now,
Yeah.
where are we with the bill? I thought we were trying to get a register with the state of Georgia
That's what the bill does.
to try to make sure that folks are not selling stuff that has not been approved.
You got it. You figured it out. That's what this bill does, and that's all it does.
Well, you know, my question is, why all the hoopla about it? If we don't have it, and we trying to get it straightened out, so that the state of Georgia doesn't have products on the shelves that have not been approved or pending FDA regulation. We are not the federal government.
Best I can tell, the hoopla is that a lot of these vape stores would like to sell products that didn't apply in that window between 16 and 20, or that have not been FDA approved. They want to be able to sell these other millions of products, even though it's only to people 21 or above.
That's
if they're
exactly right.
following.
And there's been a lot of innovation since 2020 in these products. You don't want to, it's like cell phones. You don't want to be stuck with a dial phone whenever you can have an iPhone. There's a lot of innovation here.
Senator Brass, you're recognized for a question.
Thank you, Mr. Chairman. So when is this PT, whatever it's called, the PT?
The PTMA,
PTMA, when is that filed? If they develop a new product, would they file it before they put the product to market? And if so, I'm assuming it would go before.
that's right.
Do they file it like a week before, a month before? How does that work?
Before it's marketed, it's a very lengthy process and a lot of information goes into it, and that's submitted to the FDA before it's even entered into the United States.
So my real the question I'm trying to get to is how would you word it if you didn't want to limit it to, if you wanted to open it up for anybody that applied for it, how would that timely need to be worded in this law?
I think that you could strike timely filed pre-market tobacco product application and just have it as an application pursuant to 21 USC Section 387 that has been submitted to the FDA.
But that's not the FDA's rule now. Anything filed after 2020, they make you go through the process and they have to approve it.
That's right,
No,
yeah.
no special exceptions anymore like they did back in the day in
Right.
2016.
And there's not an exception for that, and that's not what I'm asking for
So
either.
once those get worked through, those however many were filed between 16 and 20, everybody will be on a level playing field. You would have either had to be approved to be sold, or you could be sitting there waiting for approval.
That's right, yeah. I think we at least, I'm staunchly against this bill, but at the very least, we
get
have
that.
to open it up to vape products that have submitted PMTAs, so we all can rest assured there's not fentanyl, there's not dangerous illicit substances in
I think that's cutting
these.
y'all a break. If I was Representative Gaines, I would say, if you ain't FDA approved, you're not for sale. Even if you're pending back in 16 to 20, I'd say, well, by God, in Georgia, we're not going to let y'all sell something that hadn't been FDA approved. Now, he might not be able to pass that, but, I mean, that would be the best way to protect Georgians, to make sure it was FDA approved, not just applied to be approved.
If we trust the
We would be upset if somebody was selling a drug on the market that some, drug company created, and they submitted it for approval, and they said, what the heck, we're going to just start selling this, not even knowing the side effects or whatever.
So, and that's the
until
difference, right?
they rule. Yeah, that is different.
That's
But
the
it's the same
difference.
thing. Nicotine's a drug that they're vaping. Senator Redd, you got a question? You
Yes,
recognize?
sir. Thank you, Mr. Chairman. It's very interesting to see there's different ways you can smoke different things with, deliver tobacco. I know when Luke and I were growing up, there was only two things you smoked: tobacco and some of that weed behind this Luke's Lounge,
You talking about rabbit tobacco?
Is there a question in here? Because we got another bill.
But I think the concern is probably people losing their jobs if this goes through. That's what it sounds like.
Right. Other questions? I'm going to recognize the minority leader. Go right ahead.
Thank you, Mr. Chair. So one of my questions is, when we talk about FDA approved, wasn't one of the issues, though, that approval, we look at it as a stamp of approval, as though they actually looked at all these different products and said one product is safer than the other. But was it more arbitrary than that? And that's actually what's actually developed these cases.
That's
We look at it
exactly
this as a stamp of approval, but it was basically came out of nowhere, I think, when they finally did this approval process.
That's exactly right. On page 8 in the letter in your packets, I've got a whole section about the litigation that's forcing the FDA to reconsider this whole entire process. The Fifth Circuit, the 11th Circuit, which we reside in, they've all ruled against the FDA for this process. Even the Supreme Court recently has ruled against the FDA for this process as well.
And one other prior, you're also an attorney, correct?
Yes, sir.
And the Fifth Circuit's one of the most conservative circuits out there, is it not?
Absolutely.
And they ruled against the FDA on this.
Yes, that's right.
Other questions? Senator Brass, you recognize?
I got a question for the author. Would you consider it a friendly amendment if we change that timely definition of timely filed pre-market tobacco product application to include?
No, and here's why. Because the FDA has set these dates. What you're hearing, I guess, being presented is trying to legalize products that are not legal today. These products today are illegal to sell in the United States. And in fact, I pulled up FDA actually sent a letter, I think this was last year, where FDA has said, because I think really what you're talking about is synthetic products. Is
Nicotine.
that correct?
That's right.
Okay. So the FDA has made it clear that any new tobacco product containing NTN, which is non-tobacco nicotine, that has not received pre-market authorization cannot be legally marketed. To date, no NTN product has received pre-market authorization. I think that's pretty clear that these products are not legal to be sold.
What about the little pockets, like Skull Bandits, but Zen, stuff like that? Isn't that?
That's a great point, Chairman.
I'm not asking you, I'm asking the author.
The FDA's
Are those approved? I mean, aren't they
Yes.
synthetic nicotine? I mean, they're not tobacco-derived nicotine? I just wonder why they'll let you put it in your mouth but not vape it.
As I understand it, those products are approved. But I'm not an expert
With all due
on-
respect, they're not approved.
Okay, well, then I'm wrong.
All right, other questions of the author? You're through, thank you.
Could I mention just a couple quick things? I
Yes.
guess I'd actually be interested in one question. So you mentioned 34 products if this bill passes. So are you saying that only 34 products would be on the directory?
In Georgia, yes, the way
That's-
that this is worded.
That's not true.
Explain that to her, that if you applied
So
in
on
2016, you're...
So on the bill, it lists different the products that would be on the directory is on lines
65 through 69.
and through 71. So if they receive a full market authorization, yes, but 65 through 69 is the timely file pre-market tobacco product application, which, is that not the same language as Alabama and Louisiana?
I'm not sure about Alabama and Louisiana.
It is, and in those states, in Alabama, there's 950 products on their directory, I believe. And do you know what percentage is Altria? Because I think you brought them up a few times.
I'm not sure.
It's 3%, and then Alabama, it's 1%.
Well, with the language with this, I go back to lines 35 through 38 with that definition of timely filed pre-market tobacco product application. And then if you look at lines 65 through 71, it stops right there. The vapor product manufacturer has submitted a timely filed pre-market tobacco product application. That means they submitted it before 2020, and it
Right,
doesn't
and-
include anything to date through 2025.
And doesn't it say that the application either remains under review, so it doesn't mean that it has been approved?
But still, that would have to be a 2020 application. It doesn't account for the new
Correct,
products
but there's
that are
well
submitted
over
then.
1,000 products that submitted by that time.
There was 26 million before the 2020
Right,
date.
right there. So that,
And then 18 million after that. So all
Right.
those products wouldn't be accounted for because of
the
that
18 million since
definition.
then, but the 26 million before then, if they're still pending, would be eligible.
Those were all denied, except for the 34 that were listed on this.
That's inaccurate.
Yeah, that's not true. Okay, ma'am, thank you for being here. You may resume your seat. Anybody else have questions for the author of the bill? Okay, Senator Sims.
This is nowhere in the bill. I just want to know, are we sacrificing the safety? And I appreciate you bringing this bill. You know I'm going to vote for it. I appreciate you thinking about the safety of the citizens of the state of Georgia rather than productivity and mass production. The majority of the vape shops are can you tell me where they are located? The majority of vape shops
I mean, they're throughout the state.
throughout the state?
That's right. And one other thing that I think is important to note in this, because this has been one of the things I've thought a lot about in all this is, and Chairman Brass, or Vice Chairman Brass, Mr. Vice Chairman.
He's chairman of the Rules Committee.
No, I
Call
know,
him chairman,
but
yeah.
we both serve as vice chair anyway, that's not here. Chairman Brass. So, but I think a really important thing to note is, to your question, if someone files today, should they be able to put a product on the shelf tomorrow when nobody knows what the heck's in it?
Exactly.
And in the study I've seen, and maybe someone else can say this is inaccurate, but it was a study that I recently saw that was 9 out of 12 products that were just tested off a shelf in a vape shop. What was listed on the product as in it was inaccurate. So that's 70% of the products were mislabeled in terms of what was actually in them, including the amount of nicotine that was in the product. So that my issue with changing this in any way would be you would allow someone to file a pre-market a PMTA today and sell it tomorrow when no one knows what's in it.
Okay. You guys, were y'all my sign guys from the other day? Do I got sign people here? Yes, sir. Do one of y'all want to talk? If you know, I made you put your signs down because you were expressing your viewpoint. I don't want to chill you from doing that, so I welcome one of you to tell us the sentiments in that, but in this little bit more civilized manner. Tell us your name and your views on this bill.
Hi, I'm Jonathan Blow. I'm against the bill for a couple of reasons that I didn't hear brought up by anybody else. One of them is going to be the fee scheduling for violations. For the second violation within 12 months, I think if it's more than 20 products, which would be potentially even just a single brand that they weren't aware wasn't allowed. It's 25 times the retail value of that product if it's fewer than 20 SKUs. Above 20 products, and it's 50 times for that second violation.
Okay, so you think the penalties sections are pretty severe?
I think that'll close stores.
Okay. What do you guys do? What's the name of your store or stores? Do you own one?
Exhale City. I manage the one in Lithia Springs, but
And
there are almost 60 in the state.
What do you do to make sure your products are approved or eligible to be sold by the FDA? You know the FDA's rule, they've either had to be approved or be filed within that window.
Yes.
How do you ascertain that to make sure you're not violating federal law?
So they do send warning letters to companies that they found to be in violation, but one of the things that I think is really relevant is what PMTA is for. PMTA is for marketing primarily for the FDA.
Okay.
It's not clarifying that a product is safe or that a product is dangerous. It's clarifying that they are cleared or not cleared to market their product.
All righty. Any questions? Senator Ginn?
Thank you, Mr. Chairman. When you reference they are sending you letters, I don't know.
Oh, the
they-
FDA, my bad.
Okay, thank you.
All right. Thank you. I just wanted to give you guys a chance to be heard.
Absolutely. I did want to clarify one thing from the previous one. I think
Right.
someone had said that vaping started in like 2009 or something. I just wanted to mention that the Smithsonian did put out an article about Herbert A. Gilbert from 1963. If you take a look at his device that came in multiple flavors, including bubble gum and buttered rum, it's essentially the same as the blue e-cigarette that came out in roughly 2009, which is considered usually the start of American vaping.
Okay. Do you guys sell cigarettes as well, or just?
Yes,
vape
we do.
products?
At my location, it's really only Newports, but some of our locations have like every flavor of American Spirits and others.
You got any ideas why we have such a nicotine addiction in this country? I mean, really, it's worldwide, I guess.
Yeah, I mean, every culture throughout history has kind of regarded stimulants in high esteem, whether it be cacao or other stimulants. Coffee, for example. Humans have used tobacco since we've encountered it. The Portuguese brought it to the Middle East, and now the Middle East is known for hookah.
And the big draw on that tobacco was the nicotine in it, right?
Yeah, the stimulating effect, same as tea or coffee.
Okay. Appreciate you being here with us.
Chairman, can I-
Yes, you may. Senator Ginn, you're recognized for a question.
Thank you. One of the things that my kids had asthma attacks and stuff, and they used a machine that gave them a vape, some type of steroid, I think it's prednisone or something like that. Said is there any difference in what that machine uses and you know, it's a prescribed medication, but is that the same type of device that these people are putting in to bring in that vape?
Yes and no. Modern-wise, they're very separate systems, but the original vaporizer ever is 1927. J. Robinson patented an electric vaporizer for medicine application.
Okay, I just wondered, because I knew they had been around for a long time.
Yeah, nebulizers would be a class of vaporizer device.
Thank you.
Let's hold on. All right, what's the pleasure of the committee on this legislation? Got a motion to pass from Senator Albers, or who? Senator Ginn. Second from Senator Albers. Is there any discussion of proposed amendments? I don't believe any were provided to me. Did you have a motion?
So I was gonna make a motion to table this bill. We're not there yet.
I make a motion in second.
Well, you can't do both. Did you? The motion do pass has been seconded by Senator Albers,
Okay,
so
that's fine.
that's on the table.
That's my camaraderie.
Okay. And you want to just vote on that first?
I'm trying to save his bill. I think he's fixing to lose his bill. I make a motion to table it. You want to play? It doesn't matter anyway.
I think I get it. I think we'll see.
We got for a couple of days.
All right, I recognize the minority leader.
Thank you, Mr.
For
Chairman.
comment.
And I'll just kind of focus on, and this is all encompassing, of course, but just on my reading, dealing with the flavored aspect of all of this, when we talking about FDA approval, that is such a misnomer, and I think everyone really knows that. The Fifth Circuit started their opinion off by saying that the FDA sent manufacturers of flavored e-cigarettes on a wild goose chase. And everything they went from there showed how the FDA basically denied all of these applications and then magically, out of nowhere, decided that the menthol now is an appropriate flavor based on no real data, no real evidence. When people talk about it being approved and knowing what's in it, that's not what the FDA based their opinion on. What they based their opinion on basically was that they were saying that these cigarettes or these vapes would allow adults to get off of smoking and their kids would not use them. So this idea about China and all these different stuff, that's not what you're really talking about right now. That's not what the FDA based their opinion on. It's not about the safety the way you're talking about it. The way they looked at it was, what's the cost-benefit analysis? And they said that they believe that these vapes, the menthol, magically, only them would allow people to actually stop smoking and would not actually go towards children. Children would not actually want to use them. They based it on no real data because there was no real data actually they even look at. They even acknowledged that. They even told the companies, the manufacturing companies, you don't have to provide us any data. And in fact, the manufacturing companies did, and they were totally ignored. In the meantime, since that has happened, the Yale Journal of Health has actually put forth studies to show that actually flavored vapes, even if though it's not menthol, they actually do the exact same thing. They allow persons to get off of smoking, and they're not attracted to kids if you market them correctly, and that's the real key thing. Why do we believe that these stores are just automatically not going to do the right thing to make sure that children or young people do not get them? And I just don't buy into that argument. And I think when the Fifth Circuit, which is one of the most conservative circuits in the United States of America, leads off with that kind of language and says that they led these manufacturers on a wild goose chase, that tells you right there how they looked at this FDA supposed approval process. So I just want to say that in that vacuum, in this void, is all these Georgia companies, all these people now who have provided jobs to people, and they're in this void, not quote unquote breaking the law, because it is a void. Fifth Circuit case right now is pending in the Supreme Court. Supreme Court has other cases that are actually pending. They probably actually won't decide. They'll probably send it back for more research and more things to take place. So that's what's actually taking place here. And we're going to make a decision to potentially take business away from these people for a flawed method that went to place on the FDA. And we should not be a part of that, and we should not basically sponsor that. And I just wanted to make that known, Mr. Chair.
And that's appropriate for discussion on the bill and consideration. I would note that we're not in the Fifth Circuit. We're 11th Circuit, so that's not.
And there has been a big mix of results on court cases. Some have ruled in favor of the FDA, some have not. And in Louisiana, Alabama, other states that have passed this, there are flavored vapes that are on those registries. But there were not vapes that have video games that clearly target children. So there are some flavors in those states that currently have registries.
Mr. Chairman.
Yes, Senator Rhett, you're recognized.
No,
Senator Lucas, you're recognized.
Mr. Chairman, based on my friend, if we don't do anything this year on that bill, where are we? Is everybody still good?
There would not be a registry.
There would not be a registry.
Yeah, there would not be a registry. Everything else would be the same.
But what I'm saying, with the folks in here and the folks at Philip Morris or R.J. Reynolds, be able to do what they doing.
Just keep doing what they're doing.
As long as the law doesn't get enforced about selling.
And kids will still get access to these products that are infiltrating schools every single day.
Any further discussion among the committee on the motion that's before us? A motion do pass. House Bill 577, that's LC 550608S. All right, Senator Rhett, you recognize for further discussion.
I thought the senator.
It was not seconded.
Oh, okay.
He considered it and.
She seconded it, but that's, you didn't recognize it, but it's all right.
All right, you want to withdraw or do you want?
Mr. Chairman, I withdraw my motion so we can vote on this bill.
Your emotion.
All right, everybody in favor of the bill, raise your hand. You got 1, 2, 3, 4. All opposed, raise your hand. 1, 2, 3, 4, 5-6. All right, fails 4-6. Thank you, Representative. Folks, we are way past our time, but I want Representative Hawkins to make a brief presentation on his bill. You've been sitting there for an hour, and I apologize, I just can't do it any faster. We did not plan to have time probably to vote on your bill today, but I thought it might save time. We'll be back in the morning at 9. If you want to just hit us with it real quick. And
Yeah.
Yes, Senator Rhett.
What brand does he smoke?
I don't.
He's a dentist. He would never smoke.
I don't. Thank you, Mr. Chairman. If you remember last year, we had HB 434. This is a continuation of that bill. That bill was left on the table. It passed this committee last year. This bill deals with radiologist assistants. Presently, we have techs that have 2 years of education. We have assistants that moved into the state that have an additional 2 years of education. And the importance of this is that the workload is outpacing some of our radiologists right now. And the citizens and patients of this state need to be able to get the results quickly, because that determines the treatment modalities and the road to a healthy life. As the chairman said, I'm going to keep this brief. You'll notice in the section 1 that this adds radiology assistants to the present code. That's on page 2. Then on page 4, it continues that and refers to the new section, which is now on page 5. A new article has a definition of radiologist assistants. This is as defined by the Georgia Composite Medical Board, who we met with this December, who made some additions to last year's bill. And also, it's according to the levels of supervision as defined by CMS. You will notice on line 124, this deals with licensure renewal and continuing education. Then on page 8, 334 is licensure required to practice. Then on line 178, 335 are the duties. On line 189, section 336 is the board oversight of the radiology assistants. Then down on 205 is 337 is the advisory committee that's set up by the board. On 338, which is on page 10, the clarification of tasks and responsibilities. Also, that's the bill. Also, in your folders, you will find a friendly amendment, and these are articles and articulates what can be done under general supervision. That is, without the radiologist being in the hospital. That's the bill.
Is it any different than yours last year? I didn't study the two versions. I know we passed this out of here.
Yes, and that's a good question. There are some additions that were put in there by the board. If you notice on this section 13, this is actually wording that the board has for just about every licensure subspecialty that's under the Composite Board of Medicine. That starts on 5. So, yeah, there is some board language added to this bill, but it doesn't change the direction or the point of the bill at all.
Any members have questions for the author? Ms. Rawls, you are signed up to speak. I will give you the option to speak now or wait until tomorrow morning. There will be other people, I understand, have requested to speak tomorrow morning.
Thank you, Mr. Chairman. I will defer until tomorrow.
All right.
Out of respect for you all evening.
Thank you, Representative Hawkins. Appreciate your efforts. And
Thank you.
We will
Thank
be
you.
here at 9 a.m. And
You may just stay over? Or
You just spend the night.
You doing dinner and
Yeah.
breakfast? Which is
We'll come
have
up
a
with
sleep
something.
in.
Yes.
Are they all speaking in favor of, or do we have some negatives?
We got a lot of negatives.
Okay, never mind.
And I'm sure we have more in favor as well.
Okay.
It's
I was prepared.
apparently a Central Georgia issue that there are a number of, Senator Walker has provided a number of letters that'll be in your folder, and
Okay.
there's a couple others
Then we
that
should wait.
have concerns.
That's the only one I know.
All right,
Hope
thank you.
this won't be vacant.
So we're on tomorrow morning from 9 to 11. We have this room, and it's a hard stop at 11 because
meeting.
Judiciary Committee starts then. We have that water bill. I can't remember. I think it was 477 that's on our 449. What else is on our agenda tomorrow? And this is 571. And we have this bill, so really just those two bills, and then we have some update on the THC concentrations and toxicity. With that, we're adjourned. See you all in the morning.